that there were substantive provisions of the Constitution of India that were to be made applicable to Jammu and Kashmir, the directive principles of state policy, or even 356. These were all done through the application order. So that's the power under D, with consent, with concurrence. Take fundamental rights. That's nothing to do with the lists, Manoj. So 371, B1 and 2 talks of the lists. By law, particular lists. Instrument of accession, only those 4 items. That's B1. B2, other lists. That only refers to lists. That's 370. Then you come to Mallards, the application of constitutional orders to Jammu and Kashmir. Now, where any law passed under the lists, if it relates to Mallards, instrument of accession, consultation. If it relates to other things, concurrence. But substantive provisions of the Constitution were made applicable, Mallards. That also with concurrence. And this was being done between 1951 and 1957, when the Constitution came into force. Then the Constitution took over.
This was between 1951 and 1957.
After that also there were application orders. Because 371D, Mallards, continued in operation. So that's why I want to show you the 1954 constitutional order, which superseded the 1950 order. And it will show Mallards what was done. So nothing was ever done without concurrence, except Mallards for those 4 items. Never. Till date. So now kindly see page 13. PDF 13, volume 3. Documents, Mallards. Volume 3, PDF 13.
Page number?
Page 13, Mallards. PDF page 13. Running page 406, Mallards.
14th May notification?
Yes, yes. Now, kindly see, Mallards, by this time the Constitution is not in place. But they have superseded the 1950 order. So all orders hereafter were with respect to 1954 constitutional order. Because 1950 was superseded by 1954. So every other order was under 54. Now let me just show that to your lordships. The following order made by the President is published for general information. The Constitution.
Just 1 second. I just need only 1 minute to
I'm sorry.
get back.
I'm sorry.
I was focusing on something in the Constitution. Which volume would you?
Volume, documents, volume 3, PDF page 13.
Yes.
Says the Constitution application to Jammu Kashmir Order 1954 in exercise of the powers conferred by Clause 1 of Article 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, is pleased to make the following order. The order may be called the Constitution Application to Jammu Kashmir Order 1954. It shall come into force on the 14th of May 1954 and shall thereupon supersede the Constitution Application to Jammu Kashmir Order 1950. Now see what happens thereafter. the provisions of the Constitution, which in addition to Article 1 and Article 370, because that's clause C, Malad, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall apply shall be as follows. Now, preamble. That's the power under D. In with concurrence. So, Malad, you see part 1 to Article 3, there shall be added the following further proviso. Provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. Now, this is passed by the constitutional order applicable to Jammu and Kashmir. That's the solemn promise, Malad, that has been made, that you will not change the boundaries. And that's with concurrence. And that's exactly what they did, without concurrence.
Mr. Sibbal, why is it that, what is the distinction between the consultation with the government of the state, which is referred to in the first proviso to D, and in clause 1 of B? Because clause 1 of B also refers to consultation with the government of the state, and the first proviso to D also refers to consultation with the government of the state. So it will be a surplusage. There has to be a meaning for why there's two separate provisions in relation to the same.
I must explain that. I must explain that. Because if you look at Malad's B1, it says make law. It's not in relation to the same thing. So it says make law with respect. So it only deals with the lists. If it comes to instrument of accession, those 4 items.
Actually, I was looking at it this way, possibly. I mean, just thinking aloud, maybe wrong, correct me if I'm wrong. B1 refers to the specification of matters,
Yes.
on which are covered by the instrument of accession,
Yes.
in respect of which Parliament can make laws. That is B1.
Correct.
It refers only to the specification of matters in the union list, which are covered by the instrument of accession, on which Parliament would have the lawmaking authority. That is B1.
Absolutely.
Now, the first proviso to D would obviously not cover that category. Otherwise, there was no need to put the first proviso there.
Well, those only.
Just see, just 1 second.
I'm sorry.
See, the first proviso also says, provided that no such order which relates to the matters specified in the instrument of accession of the state referred to in para 1 of subclause B shall be issued except in consultation with the government of the state. So the first proviso also refers to the matters covered in clause 1 of B. It also refers to consultation, and B1 also refers to consultation. Now, possibly the meaning which can be attributed to the proviso to D is this. D says, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may make. So where the president is making an exception or modification to another provision of the constitution, then the president has been given the power. But what the proviso says is, the first proviso says that if the president is making a modification or adaptation in respect of a matter which is referred to in clause 1 of B, namely something covered by the instrument of accession, then you require consultation. The second proviso then says that no such order which relates to matters other than those referred to in the last paragraph will be made except with the concurrence. I was wondering, just thinking aloud, what D says is that if the president is making an exception or modification in the application of any provision of the constitution to the state of Jammu and Kashmir, then you require either a consultation, first proviso, or a concurrence in terms of the second proviso, right? Now, what happens if the president is not making any exception or modification at all? Does that require either a consultation or a concurrence?
Yes, Manoj, according to me, yes, but let me explain.
Because this adaptation order which you showed us, for instance, of 1954 makes modifications. Preamble will apply subject to these exceptions. Directive principles will apply subject to these exceptions. But what happens if the president is not making any exception or modification at all? Then do you require a consultation or modification in terms of clause D?
May I, Manoj, then?
Yes.
On Manoj, since you're lawyer.
Yes.
Now, Manoj, kindly look at B1 first for a minute. It says the power of parliament to make laws for the said state shall be limited to matters in the union list and in the concurrent list. It doesn't say anything more than that. It specifies the lists under which they can make laws.
Which?
Again, no, that's right. And they are not, the law has not yet been made. It's only the
Are
power.
declared by the instrument of accession.
Correct. So, Manoj, only the list, communication.
Right.
I'm not talking about, the law has not yet been made.
No.
So they are correlating the making of the law to the items in the lists. When it comes to the instrument of accession, it has those 4 items. When it comes to other matters, it is in the concurrent list, not in the state list. But they are not setting out, Manoj, what
Now,
law is to be.
one